All right, I have the privilege to be moderating over these three august gentlemen. If you want to know more about them, I believe their bios, their extended bios, are in some of the literature that was outside, right, in the program outside. Can we do a mic test real quickly? Just to hold up. Is everyone's mic?
Is it working? Yes.
It's working.
Richard Bernstein, for those who prefer
Bernstein, all right.
It's not.
Okay.
And I believe this mic works.
All right, fantastic. We're good to go. So undergirding the first two panels were the notion that the unitary executive theory has some purchase because the executive is ultimately accountable to the people. And of course, Jay in the second panel talked a lot about the expression of the will of we the people. He kept saying, we the people are voicing this. We the people wanted maybe, Trump to have all this authority, and so maybe Congress should be deferential. And of course, that is all predicated on what? Voting, elections, and indeed that is what we're talking about right now. And so we will be talking about election administration and election law for the next hour. We're going to hopefully make this a conversation that's going to focus on a lot of the developments that have happened in 2025. And boy, have there been a lot of developments that have happened in this area in 2025. But to get things going, we're going to play a little lightning round. So gentlemen, please take up your mics. Favorite Supreme Court justice of all time, but you can't name somebody you've clerked for. This is lightning!
Benjamin Cardozo, who I was shocked to find, is one of the four pictures in the Supreme Court's conference room, because I do not consider Chief Justice Roberts, who picks the pictures, to be our Cardozo disciple, but apparently he does.
All right, we got a Cardozo.
I'm a big fan of Gorsuch.
Gorsuch.
Of the current court, yep.
Trevor?
Oh, I'll be traditional and go with John Marshall, who gave us so much of the framework we now deal with.
All right.
It's like picking Lincoln or Washington as your favorite president.
Hey, there are no rules here. Who will win the World Series, the Dodgers or the Blue Jays?
Dodgers.
Go Canada.
All right.
No idea.
Are such Canadian remarks allowed at the Society of the Rule of Law? I don't know about that. Yes or no, it's silly to think we won't have midterm elections in November 2026.
I would say it's silly to think
No, this
we
is
won't.
yes or no.
Yes, it's silly.
We'll have them. I'm not convinced we'll count all the votes.
Yes, we'll have them. I'm not convinced that they're going to be free and fair and accurate.
Do I get to add nuance? Okay. Yes, I think along these same lines, we will have an election. I suppose we'll get into in the course of our discussion the consequences of that election.
Okay, book you're currently reading or show you're currently watching. Jonathan just recommended a great book. Did everyone write down that title on leadership? I think I got most of it. What are you currently reading or watching?
I'm unsophisticated. I'm rereading the Lord of the Rings trilogy. Just pure escapism.
Yeah. The King thing worked out pretty well there. So
I am always between old episodes of the greatest legal show of all time, Rumpole of the Bailey, because Rumpole sticks it to the judges in every single...
Rumpole of the Bailey. Hold it up.
Because Rumpole sticks it to the judges in every single episode, which is a lawyer's dream.
I regret to say I've just started The Crash of 1929. And the author clearly intends to draw some analogies to our current situation.
Okay, little light entertainment for when you go home at night. From a rule of law perspective, are you more worried about the lead up to the 2026 midterm elections or the immediate aftermath of the 2026 midterm elections? So lead up or aftermath?
I'm more worried about aftermath. I think the lead up it paves the way for an aftermath, but the aftermath really only matters depending on what the results are. So you got to see what the results are to decide whether or not this becomes a crisis.
Aftermath. Do the votes get counted? Does the House of Representatives, under the leadership of Speaker Johnson, care about how the votes were counted?
Both, absolutely, because I agree that do the votes get counted, do the new members get seated is going to be a crucial question, but were people able to vote is going to be the first part of that.
Okay, this one I'm going to start with Trevor because it screams Trevor. Was the new Taylor Swift album good?
It does scream Trevor, doesn't it? I have no idea.
I'm told by people I love that it was.
Yeah, I'm largely along their lines of have not listened to it. I dropped off the Taylor Swift bandwagon after 1984.
After
Or
1989?
1989.
Yeah.
That's right.
Yeah, okay. All right, last one. Does the rule of law still matter to most Americans?
Yes. Yes, I think as a conceptual matter it does. The problem is we have a large chunk of the country that willfully, blindly doesn't look at what's happening and recognize it as a challenge to the rule of law. But if you put it in the abstract, or you have the polling that says, should the president follow Supreme Court opinions, you get a yes.
Not as much as grocery prices, which I do not belittle in the least. I think the voters are entitled to decide whatever they want to be the most important issue to them.
I think if you had asked me this in the past, I would have said it matters a great deal to Americans. I think as time has gone by, I've come to a more cynical conclusion that outcomes along the lines of grocery prices and the rest matter more to people than the process of getting there. And so I'm maybe a little bit more jaded now.
Okay, well, we've got at least 200 or 250 people who are here today for whom the rule of law very much matters, and if Greg is to be believed, which I think he is, apparently there could have been far, far more people that could have come today, but he didn't know what capacity there would be for this, so thank you all for being here. So now turning to the meat of the program, the subject at hand, and we're going to start with looking back at the 2024 election. Was the 2024 general election in November a resounding success in terms of election law and election administration? And in light of that, are we in a better position today in terms of election administration and election law than we were 2 years ago? Richard, let's start with you.
I think it was a success, and the reason I would say, principal reason I would say it was a success is the one group that tried to steal an election in 2024 was the North Carolina Supreme Court. The election was for being a justice to that Supreme Court. They applied rules that were not invented until after the election, and they only applied them to favor Republican candidates in some counties, and a district judge in the federal district court in North Carolina gave it to him right between the eyeballs, declared that was a violation of both due process and equal protection. And I think it's the best, and by the way, the judge who did that, Republican, huge believer in religion. He's the head of some organization of religious judges. And I think it is the best election law precedent we have on the books.
Are we in a better position now than we were 2 years ago in terms of election administration and election law?
No, because we have a federal administration that will be tempted and may be willing to use the executive powers to try and monkey with the election. That was not the case 2 years ago. And it was in many ways not the case in 2020 because there were different people who were Attorney General and head of DHS and the various departments that could monkey with an election if instructed to do so.
Okay, Trevor, reflect on the 2024 general election for me.
Yeah, I think it's clear that 2024 was vastly better than 2020 in terms of how it was administrated. Partly that is we learned, the election world learned a number of lessons from 2020. Most importantly, perhaps, the Electoral Count Reform Act that clarified the process of who certifies results, what happens when they get to Congress, how they can be challenged. So that was an important change that could have been key in 2024 if we'd had a close and contested election. But I think the election community was prepared for a close contested election in terms of clarifying rules in the states on how challenges would work and how recounts work and meeting the deadlines of the Electoral Count Reform Act. So we were in better shape in 2024. We didn't have the close election that would have tested all of that. The second half of your question is, I think we're definitely not in as good shape heading into 2026 for the reasons Rich mentioned and others.
Matt?
So in a room full of lawyers, I give everyone's favorite answer. It depends.
Okay.
It
It depends on whether 2024, if 2024 was a success, or it depends on whether or not we're in a good position, better position.
I would say for each of those, it depends on the metrics or what you want to look at to define whether we're in a good position. I will agree in large part with my colleagues here on stage that from a federal perspective, we are in a worse position, and that 2024 has largely went very well. I would say where I'll inject disagreement onto a panel where we probably predominantly agree. To say that I think at the local level, we're in a much strong. It went very well in 2024. I've heard from some great election officials who were there in 2020 on the ground, and in the year following, as there were audits and investigations and allegations thrown around, that process was very lonely. Particularly for Republican election officials across the country who wanted to do the right thing and stood up for that. And in doing so, exposed themselves politically for taking those positions. And I think much of that environment has become better over the last 4 years. There is a stronger sense of community and cohesion for local election officials to be able to stand up and do the right thing. Whether it's sufficiently strong, I suppose, is still to be determined, but I would characterize it as stronger than 2020, and even in the time period since 2024, and as we head into 26 and beyond, I think it continues to strengthen. I have the privilege as part of my role at R Street to travel around the country and engage in a project of promoting trust in elections among conservatives, and I visited now about 14, 15 states in the last 24 months. And I think at that local level, folks they're not necessarily tracking a lot of the things that drive pessimism here in Washington, D.C. for good reason, but they're largely immune from those conversations by their distance and a greater focus on local issues. And there's a stronger sense of camaraderie. There's better professionalization of election administration at the local level than there was 2, 4, 8 years ago. And a better sense of community that's being built. And I'd like to hope that means that for 26 and for 28 and beyond, if we find ourselves in a situation where shenanigans are afoot, it'll be better handled than in previous cycles.
Trevor?
I hope Matt is right in terms of the election official community. What I see at the local level, though, that's really troubling is that all of the effort and the noise and the push in local elections is to make them less reliable and less accessible, meaning the idea that we shouldn't have any machines involved in counting votes. They should be done by hand, which would have the opposite effect in terms of reliable counts. The attempt all across the country to shorten election voting opportunities, the hours, early voting, all of that, that's where the energy is. And then you add to that the threats we feared in 2024 that I think we could see in 26 in terms of a refusal to certify at a local level, county level, election results because the party in power doesn't like the results. I think there's just less faith in the conduct and integrity of election systems by components of the electorate and a desire to change and restrict the ways in which we vote.
I do want to distinguish, I think you're talking about activists and state legislators and maybe federal representatives.
Yes.
Matt's talking about elected election officials or election officials, but I know you also talked to some state representatives as well.
Yeah, and this gets back to my point of it depends. Right? It depends on what you're looking at and what metrics you're using to evaluate how confident and comfortable we should be heading into 26. Some elements of the electoral system have strengthened, some have deteriorated. And how those two things play against each other, I suppose, will depend on the facts on the ground.
Such sophistry.
Yeah, one thing I'd like to add is I do think, I agree, there are lots of problems with local officials. But I think the state Supreme Courts have, including the state Supreme Courts that are dominated by Republicans, Georgia, Arizona, for example, North Carolina obviously is a counterexample, have been very good, in my view, in reining in the local officials who want to, the local election officials who want to do things that they do not have statutory authority to do. all of that gets tested. A lot of state Supreme Courts are elected. So far, I'm unaware of a Republican state Supreme Court justice who has lost a primary, for example, because they've called it straight in elections. But, you know, we live in the age of the unimaginable, so...
There's certainly been pressure campaigns, even if there haven't been election campaigns, to target the people who ruled against some of the challenges to the 2020, 2022 elections on the state level.
As you well know.
Yeah, it was a lonely road, and as Greg mentioned, I'm the former Maricopa County recorder. So for those of you who are unfamiliar, President Trump thought about elections a lot over the last few years, since 2016, well, really since 2012, but since 2016, and then he had some thoughts on the 2020 election that were voiced at various periods over the last 5 years. So when he got elected a second time, I expected that there would be immediate, decisive, large action on election administration, and I was a little bit offended that it wasn't part of the first, say, 50 executive orders that were signed. In fact, it wasn't until March 25th, 2025 that President Trump signed an executive order titled Preserving and Protecting the Integrity of American Elections. And among other things, it aims to undo one section of the National Voter Registration Act, the NVRA, regarding what is required for documented proof of citizenship, whether that should be required, not just attestation. And then it also seeks to prohibit states from accepting mail ballots if they are postmarked on election day, and a good number of states allow this in at least some capacity, red and blue. By some counts, that's about 30 states, and so this would have a material impact. Now, that was March 25th. Now, one of the first groups to be involved in a lawsuit was Trevor's organization, the Campaign Legal Center. So, Trevor, can you sort of tell us the status of the litigation, and is this a dead letter, as some people seem to think, or could this impact how we administer elections in 2026?
Well, briefly, this may be the rare instance when people drafting executive orders actually looked at the Constitution, and that may be why it took a while to produce a cobbled together order. Because as I think everyone in the room knows, the Constitution is pretty clear on this subject. There is no mention of a role for the president. There is a presumption that states will run elections under state law unless Congress passes laws to the contrary. And so you have states running elections, you have the ability of Congress to act, which it has in a number of instances, of course, implementing the 14th and 15th Amendment, but otherwise setting dates of elections and so forth. There isn't a role for the president here. Then we have the whole first discussion we had of unitary executive and independent agencies, because you have the Independent Federal Election Commission, the Independent Election Assistance Commission, and those two have specific statutory roles. The FEC really not involving running elections, the EAC more so in terms of providing funding and certifying forms. So that's the context in which the White House issued an executive order purporting to tell the EAC that it had to change its forms and require proof of citizenship to register to vote, and purporting to tell states that they couldn't accept ballots received after Election Day, even if they're lawfully cast before Election Day. So that order was immediately challenged. CLC led one challenge. There have been, I think, 5 or 6 challenges to different pieces by different plaintiffs, including a number of states. And so far, the order has been blocked by courts. There's a preliminary injunction in our case. There is discovery in others, but none of it has taken effect. But what it purported to do doesn't have a direct line at the moment to results. The EAC hasn't done anything. The question of whether states will choose to change their laws is still open. And so you see Republican state secretaries of state or legislators saying, we need to comply with the executive order and change our laws so that we don't accept ballots after Election Day. But I think the order itself is, for the moment, a dead letter.
So it's pretty hard to square this with the National Voter Registration Act, which explicitly says what the requirements are for proof of citizenship. And the president presumably can't just rewrite that through an executive order. And indeed, you have sued on that point, as well as on constitutional grounds. But on the question of whether or not states can allow mail ballots after Election Day, if they've been postmarked on Election Day, rests on a little bit of a fuzzier ground, maybe, in that there's been at least one circuit, the Fifth Circuit, that has said, no, Election Day means it has to be back to the election office by Election Day. And so, Richard, you've published an article on, in fact, the Society of the Rule of Law's website, among other places, that's discussed this. So tell us about what's the sort of the dividing theories here, and what do we think the future is?
And here's why it's particularly important. The map for swing states for House elections is very different than the map for swing states for a presidential election. Go look at the Cook report where the swing seats are. The state I live in now, California, has 11 swing seats. It's obviously not a presidential election swing state. California happens to be one of the states where they will count a ballot postmarked. Remember, postmarked. It's not we're guessing that the ballot was mailed by Election Day. Postmarked by Election Day, they will count it even if it's received for a period of time after Election Day. So what the issue comes down to is the essence of an election choosing by voters versus a state process. Because if it's choosing by voters, as long as the voters choose by Election Day, the pro-voting side of this is going to win. If it's a state process, then the question is, well, what's essential to the state process? Is only counting essential, which happens after Election Day? Is receiving essential? Well, as a former Scalia clerk, I was taught to
One just says that. Yeah.
I was taught to read. And so
It will be disappointing for the other clerks to learn that they did not learn that.
oh, well, you know, I was a clerk back in 1987. It was very much in vogue not to read back in 1987, but that's a different story. So listen to what the Constitution says. Congress has the power under the Constitution to enact a law for, quote, the time of choosing the electors. Choosing. Okay. Well, what does it say about senators? The Elections Clause says that states hold elections for senators is, quote, choosing senators. And then there are provisions for both senator and representative that say when elected, the representative has to be, or senator, from the state in which that's the pronoun they used back then, in which he has been chosen. And there's all sorts of choosing language in the statutes as well. Here's the problem. Here's why this might be a difficult issue when it gets to the Supreme Court. And one way or another, I think it will get to the Supreme Court. It's not the elections they remember as kids. As kids, they don't remember ballots being received after Election Day. Here's the problem. Go back to 1788. Nothing in our elections today. Here's something Republicans love. Advanced voter registration did not exist in 1788. Didn't happen anywhere. Didn't start until the 19th century, and even then slowly. So if you're faithful to the text, the pro-voting side will win. But if this issue gets to the Supreme Court, and I think it will be at best 6-3 from the pro-voting side, and it may be 6-3 the other way, or 5-4 from the pro-voting side. And if you'd like to know more about it, and you really
See the article.
I have a 30-page piece up on the SRL website.
Societyfortherule-of-law.org, right, Greg? Yeah, there we go. Okay, so that issue exists independent of the executive order. Will it be heard by the court this term?
Well, right now there is a case pending. They had the opportunity last Friday to grant cert. They neither granted nor denied nor relisted the case because there's a standing issue in the case and there's another standing issue pending before the Supreme Court. So in the opinion, I asked yesterday Carter Phillips, the dean of the Supreme Court Bar, what he thinks is going on. And he said he thinks they are probably holding the substantive issue until they resolve the standing case, which will give them relatively little time. In the interim, however, there was a challenge to the executive order. There have been a number of them, as Trevor said. The one that's most advanced on this issue was in the district court in Massachusetts, and the briefing on that started on October 7th, but wait for it, the briefing has been stopped by the shutdown. And the briefing will not start again until the shutdown is over. So if the shutdown goes on, and it's interesting, the government has the choice as to which cases it goes to court and says, we need to go, we need to keep going, so we will keep going. And, oh, it's okay to go slow. And surprise, surprise, the case that might say they can't tell people, they can't tell states, they can't count these votes, they're willing to go slow on that one.
Yeah. Trevor, were you going to say something?
Well, just to make sure everyone understood, what we have here is a conflict of circuits, because the Fifth Circuit, to my surprise certainly, has come out and said no, under the Constitution and the statute, Election Day means you have to actually have the vote in on Election Day. Every other circuit that's considered this has come out the other way. So it's clearly teed up for the court. The question is in which case and how quickly.
Okay, and the shutdown will continue until morale improves, undoubtedly. Matt, unlike some lawyers, you not only know how to read, but you know how to talk to people as well. And you talk to a lot of Republican state legislators and Republican election officials throughout the country. What do you say when when President Trump says, all I'm trying to do is make it such that people have to show proof of citizenship, documented proof of citizenship, and that seems pretty reasonable. People are pushing back on that. How do you answer that and say, like without sort of saying, or do you put a stamp of approval on the executive order from the president in that respect?
That's a good question. I will get to that, but I'm going to take just a moment to point out, as was just pointed out, that words have meaning. But as a Scalia clerk, as you are well aware, he has pointed out that a healthcare exchange administered by the states, including the federal government, means words no longer have meaning, I believe, from one of his dissents. So we're now in a post-words meaning environment, according to Scalia.
He always thought we were in a post-words environment.
But to your question, how do you deal with it? It is tough. So I will point out a couple things here. One, on a personal level, I know we're talking a lot about process and procedure and legality, but on a personal policy level, I am generally fine with increasing some of the standards for citizenship or proof of citizenship, though my personal preference on this is that work be done behind the scenes. It's not a burden on the voters, but should be a cross evaluation of existing databases, and there need to be procedures for making sure that those are accurate and that there's a dispute resolution, et cetera, et cetera. But I don't, as a general matter, have a philosophical problem with increased rigor for citizenship. And similarly, I have no philosophical problem with ballots being in on Election Day. I actually think that's good process for the purpose of speeding up results in this environment that we're in. As was pointed out, our modern election environment is not the same one we grew up with. I grew up in Southern California, and we voted in our neighbor's garage in a small cardboard booth that was set up, and it was a big block party on election night. And
wait until the president hears that.
That's the thing, right? Like, imagine now, like garage polling places, and it was a very common occurrence in California in my youth. And so things have changed. And reflecting on that change, I think, is important. So to your question of how do we talk about this, how do you grapple with it, it goes back to really one of the earlier questions you have. How much respect do Americans have for the rule of law in and of itself? Because this is one of those circumstances where I can empathize with the policy aims being sought in those two particular provisions. I might have some disagreements on the details, but it's the broad thrust of the direction. But the problem here is the process. These are questions that are naturally to be decided by the states in elections run by the states. To the extent that the federal government wants to play ball on this, it runs through Congress. And because Congress, as was pointed out in the Constitution, has some influence on the time, place, and manner of elections, and can determine that. And these might be questions of whether it's time when it comes to things getting back, or manner, probably a bigger catch-all. Congress could provide some guardrails on this. There's no place for the president to do that. And as we talk about this, it's important to point out, sure, you might like what this president is doing because he's effectuating your policy goals. Are you gonna like the next one? Did you like the last one? Because everyone in recent memory can point to a president they don't like. I think that's a pretty universal experience we all can agree on. And so recognizing that it doesn't take much for another president to take over that you don't like.
Right.
You got to think about the powers that you're giving this current president in exchange.
So to invoke our moderator from the last session, Jay was saying we care about process. We care about process, even if we might agree with the end result. I just think that now there are some people who are invoking instead Allen Iverson, and they're saying process? We're talking about process here? Instead talking about results. Yeah. Trevor.
Well, I think it's important to understand that this executive order is the first shoe to drop. This is a president who is clearly determined to affect the results of the midterm elections using the powers of the federal government, including powers he does not have, and that the challenges to those may be ineffective or untimely. So the executive order is putting a footprint down saying, I'm concerned about election fraud and I'm doing something about it. So we're talking process here, but the end result is going to be, that is, I think, the first step in an attempt by the president to influence, to change, to direct the outcome of this election. So that's why it's important, is it's asserting a power he doesn't have that he then intends to assert, I think, more broadly in the next year.
So stay tuned for the next executive order. Richard.
And if I could...
Or just...
Or troops in the streets,
Okay.
or all sorts of things.
Well, and if I could add to that, and I can use the ballot receipt issue as an example, suppose this issue isn't resolved by Election Day.
It creates
And
chaos, confusion.
The President of the United States is sitting in the White House, and the House has come down to a couple of seats in California, and they're still counting the votes. Do you remember when he fired the BLS commissioner because he didn't like the numbers? And it's not just troops. A phone call to Ed Martin, Dan Bongino, and Kash Patel, put 200 people in vans, seize the ballots. We think it's illegal to keep counting those ballots.
Okay, so...
Do we think that any of those three people would say, sorry, Mr. President, we don't have the authority unilaterally. We can go to court and ask for a ruling. We don't have the authority unilaterally on our behalf to go and seize the ballots. They will seize the ballots, in my view, and that is why it is essential that these and all other election issues, whichever side is right, be resolved before Election Day rather than after Election Day, when, for example, voters don't have the opportunity and don't know, not only do I have to send it in the mail before Election Day, it has to be there, so I'll vote 10 days early instead of 2 days early.
And that was a principle that was very much invoked in the North Carolina case, which is the rules of the game must be set. If you don't like them, challenge them before the game commences, but once the rules are set, then we play by the rules of the game. Now, Richard took us to a pretty dark place just then, so to continue down that road, Greg, I'm going to do the positive at the end. I know that was one of your instructions. Most of the commentary about federal interference or federal manipulation or not having a free and fair election in 2026 revolves around President Trump. But I go to a number of these meetings where we brainstorm the worst case scenarios, and all three of you have also participated in that. And one of the most common concerns voiced at those meetings is that it won't be President Trump, but the United States House itself might not choose to seat its members because of alleged election irregularities? The House seats its own members. Is there anything to that?
Well, you start with the fact that the old House disappears. The new House is sworn in on January 5, and it is the one that elects the Speaker and, quote, deals with challenges to membership. But who's in the new House? It's a chicken and egg issue. You have certifications from the state. So running down the possibilities, if you have a recount going on, you don't have a certification from the state yet. So it is possible, likely, I think, in a close election with a number of contested seats, that you will have some recounts continuing, and so you won't have full election results when the House meets. Then you have the possibility that the old House, i.e. the current Speaker and committees of the House, would decide that elections were in fact potentially invalid. So you'd have a certificate from a state, but there would be challenges to that certificate saying there was, let's just say, fraud in the election. Votes were counted that shouldn't have been counted. And under those circumstances, there is precedent in the past for the leadership of the outgoing House to refer matters to a committee of the House, which then rolls over into the new one. But in the past, we've never had that happen in a situation where control of the House may change. So it was the leadership of the old House that was going to be the leadership in the new House, and I'm specifically referring to a contested election in Indiana, that decided we're going to not accept the state result and take a look at it in the new House. What I don't think any of us know is what happens in a situation where the leadership of the old House is not moving forward with certifications it's received from states, all of which are received by the clerk of the House. So in theory, on January 3, the clerk reads the certifications and the new House assembles based on those certifications.
The way I
Richard, is this so sort of to my valid question? Is this a valid concern, or is this just people who have too much time on their hands, getting together in Washington D.C. and are just creating monsters where there should be none?
This is a valid concern. Let me give you the legal answer, and then let me talk about something that's happening today as we speak. The problem is, unlike in 2020, Constitution doesn't actually give Congress power to rejudge a presidential election. It only gives Congress power to count the votes. The Constitution makes each House the judge, not the sole judge, so it's unlike impeachment, but the judge of who won elections. So Speaker Johnson, who is Speaker Johnson because he was the principal legal election denier, and by that I mean he did it based on legal theories rather than claiming that there were gremlins in computers. He emerged from being an obscure Republican congressman from Louisiana to being the Speaker of the House by being the principal legal organizer of election denialism. So that brings me to today. Today, there is a congresswoman from Arizona who has been elected, who has been, to quote the Constitution of the United States, chosen by the people.
So this is Adelita Grijalva, whose dad died, and there was a special election in southern Arizona. She was elected. It was how many days ago now, Richard?
Yeah, it's a month.
By 63% of the vote, and the election is not contested.
An election has been certified by the Arizona Secretary of
Okay.
State. So just last night, the Arizona Attorney General filed the lawsuit. And I will admit that I'd never read the critical statute until last night. So I thought, well, maybe it's going to be difficult. Let's read it together.
Which we all know he's very good at now.
It's the only thing I'm good at. The only thing I can do is read. 2 U.S.C. Section 25. Now, it's a broader statute because what it principally covers is what happens the day Congress convenes, right, the first day of the new session. But part of it is about what happens when a vacancy is filled. So there are a couple of ellipses in the statute, but let me read you the key words. And trust me, it's an honest reading. An oath, quote, shall be administered by the Speaker. Let's stop there. Shall be. Sounds like a duty, not discretionary. To the members, okay, she's a member, who afterward appear. That's the part that deals with people elected in vacancies, or back in the old days when this statute was originally enacted, their horse didn't get them there in time for the first day of the session. There's no discretion, and yet the Speaker of the House, for weeks now, has refused to seat this person. In my view, it's the canary in the coal mine for 2026. They will do everything in their power. I think there's an argument that the old House doesn't have much power, and that it's only the new House which has power, and it's impossible to know who's in the new House until you elect a speaker, and you can't elect the speaker until you know who's
Richard,
elected.
do you think it's that devious? Do you think that this is not just, that this isn't just, like political gamesmanship in the moment? Do you think that this is a precursor to 2026?
I will make a confession. I think everything's that devious. So I might not be the best person to ask, but I believe, the election deniers have profited. Pam Bundy, Speaker Johnson, basically everybody in leadership at the Justice Department and the FBI were prominent election deniers. They emerged from obscurity by being election deniers.
Okay.
Do I think they will do anything in their power? And as I said, because the Constitution actually makes the House the judge of its elections, they actually have a legal leg to stand on, which they did not
All right.
in 2020.
Yeah, no, I want to bring in Matt here. Matt, is this the concern we should be watching, or on your draft chart, it's not even in the top 5?
So it's actually pretty high for me, and a good reason for it is that when I look at ways that you can engage in shenanigans for 2026 or 28, using kind of some principles of game theory, you work backwards. Who cares whether there's disputes up front over who should be registered, or whether you receive a ballot 21 days out, or if it comes 2 days late, and whether that disenfranchises you, and some of those normal fights that we have. At the end of the day, you need to know that when the ballots are cast and counted, that those people who win have a job to go do, and will be able to show up. And I think a couple of things that I would point out into this discussion. One, in that kind of period of transitions between Congresses, figures like the clerk of the House are incredibly important. In theory, folks like the sergeant at arms might be quite important. And then the questions become, well, who are those folks, and how did they get that job for that time period? Well, those kinds of things could change, let's say, in early December before the old Congress leaves, in order to find allies who will play ball in this space. Something else that sticks out to me, I think folks in this room can recognize one of the best bastions for rule of law in these recent times over elections has been the courts. And in large part because judges have done the right thing, even if perhaps political allies and friends wished that they hadn't. I look now at this kind of circumstance and think, in my darkest moments over a glass of bourbon, the president is claiming that we can't trust the results in California. The outgoing speaker is saying, we are not going to trust these results. It's late December, right? Like, we're already seeing this come. And we start to see the lawsuits filed. Things percolate all the way up to the Supreme Court. And a couple of things stick out to me. One, again, I'm sure many of the folks in this room are familiar, the premise of whether this is even justiciable. We're going to get questions from Baker v. Carr over whether or not this is respect for coordinate branches. And this rightfully belongs to Congress. Now, of course, we have other precedent. Powell v. McCormick from the late 60s, where there was a question over whether or not a congressperson who had engaged in misconduct could be seated. And the court came forward and said the only requirements for being a member of Congress are outlined in the Constitution, and misconduct is not one of them, so seat them. And the Congress at the time relented. And the only reason that was enforceable is because Congress wanted to abide by the norms and have respect for the court's decision. They didn't have to. And I imagine, as I kind of continue to unwind the cynicism here, imagining that scenario where the lawsuit takes place and the Solicitor General comes forward and says, we agree that these results in California can't be trusted. We don't think that these people should be seated. And you find the Chief Justice and his colleagues sitting around looking at each other and thinking, if we write an order saying that you must seat them and it gets ignored, what is that going to mean for our institution? And will they be willing to do that?
Are these guys ever going to have some guts?
To go, but this is a good question.
If they sit out, whether the people chosen by the people get to go to Congress, what is it that they won't sit out? Now, I'm going to make Greg happy. Here's my optimistic moment. Moore versus Harper was a case in 2023, and it was about whether state constitutions could be used to restrict gerrymandering. The Supreme Court having decided 4 years earlier that the federal constitution did not restrict political gerrymandering. And a number of the justices who clearly, had they been North Carolina Supreme Court justices, would have ruled the other way, ruled that this was a matter for the state courts, that the state constitutions did apply, and absent something really egregious, the state courts would interpret their own constitutions. My moment of hope is that the 6-3 majority in Moore versus Harper, and they're all still there, will say, and I'm going to quote Justice Scalia again, his favorite expression was, fun's fun, but you can't die laughing. And they will realize that if they allow people duly elected, certified in their states, not to become members of Congress, then the game's over. The game's over. Then we're not the opposition, we're the resistance, and I'm too chicken to do
All right, I'm gonna give Trevor. Trevor, do you want 30 more seconds on this topic, or are you good?
Well, I'm just going to circle back to something that we've walked past, which is we're already in this crazy world of mid-decade redistricting for purely partisan gain, and the whole country is watching this play out, where the avowed reason is to change the election results before anyone's voted, and the response from the other side is, well, then we're going to change it too. So that's only one of the pieces at play here. But I agree that I think the situation we're in does not have limits in terms of what the president and his party will do to try and retain control of Congress.
Okay, Matt, wait, Matt, hit me with 1 second. One sentence.
Because the final kind of conclusion I wanted to get was whether or not the court makes that decision that they want to demand that the Congress members be seated. They don't have a lot of levers for enforceability other than norms and public pressure. Because if the executive branch is unwilling to act or is willing to act in opposition, and if the members of Congress, or at least the outgoing Congress, aren't willing to act, the court can't self-enforce.
Donald Trump might, and to his credit has not, in my view, so far, violated an explicit 3 times repeated court order.
From the United States Supreme Court.
From the United States Supreme Court, and whose Solicitor General promised the United States Supreme Court that they will follow Supreme Court decisions, not only in that specific case, but as nationwide precedents. Even if one assumes Donald Trump would be willing to violate a Supreme Court order, I believe Speaker Johnson would not. I don't think he has guts of that level. And I think there are enough Republicans. I saw one of them on TV last night, Kevin Kiley. He was objecting to what's being done to this Arizona Congresswoman. I think there are enough Republicans in the House who would bolt that he would not have a majority for refusing to seat someone who the Supreme Court said you have to seat.
Okay, and you heard the broad affirmation from the crowd on that point. So remaining, we have DOJ requests to states. We have redistricting mid-decade. We have potential National Guard at polls. We've got 11 minutes for all of that. But no, what we're instead going to talk about is one of my heroes over the last few years is Liz Cheney, and she told me, Stephen, since 2021, I've got to make friends with a lot of new friends, and she said they're called Democrats. So I think all four of us hail from the political right in various forms at some point, but the pro-democracy coalition has introduced us to new people. I was talking with someone from the Carter Center, or before this, and I said, we're marching together now. I said, afterwards, when this is all done, I might have some ideas I want to run by you on tax policy. I don't think you guys are so great on that, but, we'll worry about that then. Are there rifts within the pro-democracy coalition leading up to 2026? Trevor, you interact with a whole amalgam of groups. Do you sense that there are going to be places where we're not going to be united as a pro-democracy? Even the people in this room are not going to be united on some election situations in 2026.
I think my concern is that if we have an election that is regarded as interfered with, whether it is the gerrymandering we're seeing or attempts to make it difficult to vote, and let's just throw into that troops in major cities on election day in blue states. And after that has happened, it appears the Republicans have retained control of Congress. There isn't an argument that the choosing was false. The choosing was influenced by these events. But if that's the situation we're in, I worry that there will be a split in the democracy world between people who say this is an invalid election because it was rigged versus people who would say we don't like the results, but this is in fact the decision of the voters and we have to accept the rule of law. I think that's going to be a pressure point if that's where we are.
I happen to agree with that one. Richard, any rifts that you potentially foresee?
Not so much a riff. I do think that sometimes the Democrats are their own worst enemy. This is a very difficult court for them. There are members of the court who are genuinely suspicious about the activity of Democrats in elections. 3 of the members of the court participated in the Bush versus Gore litigation on Bush's side, and I think genuinely believe the Democrats were up to no good in Florida, and I think it colors their view of these things going forward. It's not fair, but the Democrats have to be really, really clean. And by that I mean not bringing lawsuits before a favorable district judge who's going to say the due process clause requires this state, contrary to its statutes, to do this, that, and the other thing, because those lawsuits are not going to, particularly late in the day, those lawsuits are not going to make it through the Supreme Court. They're not going to get more people voting. This Supreme Court is not going to say that the due process clause overrides state statutes to allow more people to vote. So I do worry, and I understand everybody has clients,
Yep.
but I worry that the focus should be, quite frankly, on defense rather than on offense, because offense does not increase your credibility with the 3 people at the end of the day who you have to get, which is, like it or not, Roberts, Barrett, and Kavanaugh.
Yep. So you're saying that Mark Elias shouldn't be the tip of the spear. Okay.
Yes, that's what
you don't have to answer that. You don't have to answer that.
Yes, on the record, yes. I admire him in a lot of ways. When I was a practicing lawyer, the first decision you have to make is, are you the right client for this case before this court? And the answer is rarely going to be in the Supreme Court, Mr. Elias, despite his great skills.
Matt, rifts within the pro-democracy community?
I think Trevor pointed out the correct area of rift. It's going to be the folks who have a disagreement with what the rules were coming into the election, and then say as a result of those what they perceive as unfair rules, the outcome is manifestly unfair. The election, whether they use the word rigged or not, that's I think the area where the rift will be. To me, as I see this, is I also recognize that in our world of negative polarization, and as I think David French coined around nut picking, where you try to find the worst example on the other side and hold them up as emblematic of the entire other side, that kind of practice will make the information environment and political environment very difficult. I think of 2 particular examples of this in recent times. One, after Katie Porter lost her primary and claimed that the election in California was rigged, a whole number of Democrats or folks on the left pushed back against that. But that wasn't always received by folks on the right. All they gathered in their news media was that there's a Democrat claiming that it's rigged, and let's grab some tweets or X posts or whatever that show that there are people who support her allegations of rigging. And so then they say Democrats are also saying that the elections are rigged. And the other example of this is more recent. In the wake of Charlie Kirk's assassination, I think a vast majority of elected Democrats and folks on the left in positions of authority and influence came out condemning the act and political violence. On the right, however, almost none of that got through.
That is not what was seen.
All was seen were the reactions online or the worst kind of statements where, I feel sorry for the bullet for having to go through his, his body. And those kinds of statements, it's all that made it through. So that for so many on the right, they can paint with a broad brush and say all Democrats reacted in a way gloating the death of Charlie Kirk. I think about this kind of scenario where these rifts, I think, are likely to exist. Human beings will interpret events differently and hold different values and priorities. We'll see that kind of nut picking happen again, even if the rift is it's a relatively small amount that are claiming unfairness.
I'm going to slightly defend my Democratic friends here. There was a Senate election in 2024 in Pennsylvania. Virtually every decision went against the Democratic Senate candidate. I cannot think of the wildest Democrat, it was a very close election, who has complained about that, who has suggested that amounts to rigging, et cetera, et cetera, et cetera. I think this is an issue where, if there are issues in 2026, if they get decided by the U.S. Supreme Court, and if the Republicans in the House abide by them, or even if the Republicans win, I just think if it's decided by federal courts, Democrats will not like the outcome, but there won't be anything.
But Matt's point is that what Republicans are seeing is sometimes different from what Democratic elites are saying. But I have 4 minutes left, and I have instructions from Greg when he sent to the moderator, and it said, overall, the last year's event was very well received. The one note of criticism we got from some attendees last year was that the tone was too downbeat. So now with 3 minutes and 30 seconds out of the 60-minute panel, say something positive about election administration and the rule of law in election law.
I'm happy to. I'll get to talk about my favorite thing, and I'll make it short. And I'll do it with only positive spin. In 2026 here, we're about to go through the semi-quincentennial, the America 250 celebration anniversary of our
Say it
country.
again for those who don't.
Semi-quincentennial. If you do the math of the Latin, it makes out to half of 500. 250. And this gives us an opportunity to elevate an identity of American above partisan identities. Will it be effective? I'm going to be positive. Yes. We also have an opportunity to celebrate, chant USA, USA for a World Cup. We have these kinds of fun, brings everybody together, inescapable cultural moments coming in front of us. And I'd like to think that we will have this moment of national bonding and unity that will carry us all the way forward into the election and beyond.
All right, so soccer will save America. We always knew it. I like it. Richard, something positive.
I think in general, Americans do not like post-election day subversion. I think that was true in 2020, and I think there will be broad pushback across the society if some of the things that I'm worried about, like seizing ballots, start to happen.
Yeah, I subscribe to that. I think we are in a better position because we understand the threats we're facing. And having this sort of a discussion a year ahead of the election, understanding what some of the dangers are, is helpful. And I think a fully informed electorate and fully informed decision makers who are aware of those threats is a good thing. It enables us to prepare for them and, I hope, avoid them.
All right, Matt Germer, R Street, Richard Bernstein, Society for the Rule of Law, Trevor Potter, Campaign Legal Center. Please give them a round of applause. Thank you all.